Walls, Immigration Under the Biden Administration. And we are thrilled to have Stuart Anderson, Executive Director for the National Foundation for American Policy with us today, as well as Dan Berger, partner with Curran, Berger, and Kludt, and Paul Hughes, partner at McDermott, Will, and Emery, LLP. You may have noticed that a lot of things in New England have gone virtual this season. We virtually won the Super Bowl. Wait, somebody's telling me we actually didn't play in the Super Bowl, but some of us feel like it was a win. But the other big thing that has gone virtual is NAFSA, our regional spring immigration workshop. So SIW is coordinated by a fine group of partners and professionals in the New England area, the Government Regulations and Advisory Committee, so the GRAC team. And so this link here will give you a sense of what that group is made up of. I'm the current chair for this year. There are some updates to this link, so you'll notice that some of the folks that say they're in elect positions are actually now in position, so we'll be updating that soon. But I do want to welcome you on behalf of GRAC to this first session. So we do have a few housekeeping Zoom tips for you to make this experience as positive as possible today. We do encourage you, where you see the mute button, you'll see ... three dots, and that if you use that function, you'll have the ability to rename yourself. So we'd love to see what your name and your university or college is, or your affiliation. So feel free to change your name there. We, this session, because we have over 200, nearly 300 people registered for this event, it's actually one of the larger SIW events we've had. It exceeds what we might have had in person for a day in Worcester. So this is similar to what would be our keynote address. So it will be a session where there will be more limited communication between participants. So everybody is muted, and we'd ask you to turn your cameras off. Since there are 300 people in the room, you may also find that you can view things a little bit more easily if you set your Zoom settings. Under Stop Video and Video Settings, you have the option to hide non-video participants. So you'll just see the panelists in the room, and everybody else won't be taking up space, real estate on your Zoom room. We do, though, encourage you to use the chat feature to chat with colleagues. You're also welcome to ask questions. Keep in mind that because this is a keynote address, there won't be a formal Q&A, but we still will watch the questions for certain comments, and it does give us an opportunity to chat amongst ourselves. So those are the Zoom tips for today. Without further ado, I again want to announce our panel, and I'm going to turn it over directly to Dan Berger to start the conversation. Building bridges, tearing down walls, immigration under the Biden administration.
All right, thank you, Andrea, and thanks everybody. So what Stuart and Paul and I have talked, we're each going to share a bit about our experience, what we've been doing the last few years, and what we're looking towards in the future. And we'll start with Paul talking mostly about litigation, which is his forte, and then Stuart talking about the research and policy, and then I will finish up. I feel as if Paul and Stuart should get should have longer explanations of what they've done. Please Google them. They have interesting bios, but we don't have a lot of time, so I'd really like to dive into hearing what they have to say. So, Paul, would you like to get started?
Great. Dan, thank you so much, and thank you, NAFSA, for having me. It's a real pleasure to be able to speak with this group. So I've always handled litigation. I'm a litigator by trade. I'm not an immigration expert first and foremost, but immigration has always been part of my practice from law school on. However, over the last 4 years, immigration took on a far more substantial part of the work that I've done, given sort of obvious circumstances. So what I thought I would do is start by just a few minutes describing what I've been up to over the last 4 years and some of the lessons that I've learned in connection with the several cases that I've litigated, and then pause for a couple moments and think about what that might mean going forward, how we can apply some of those lessons over the next 4 years, where I think we're all quite a bit more optimistic as to what policy we may be seeing coming out of the administration. So my story really begins about 4 years ago, just around this time, maybe 4 years and a couple weeks ago, when the initial travel ban came out. You know, like many in this country, I was quite infuriated at the direction that the administration was taking with the travel ban. I decided to jump into action pretty quickly. I got in touch with a law school classmate of mine who does immigration work at the Legal Aid Justice Center in Virginia, Simon Sandoval Moschenberg. And we decided that he was going to set about finding plaintiffs to challenge the travel ban, and I was going to put together the legal strategy. We were in court within about 24 hours of the travel ban coming down. We filed one of the first cases in the country, Aziz v. Trump in the Eastern District of Virginia. And on Saturday evening late, we got a injunction, or actually, sorry, a temporary restraining order, a TRO, precluding the enforcement of the travel ban at Dulles Airport. As a result, several individuals were able to enter the country. Some families that were turned away, we were able to get back and returned to the United States. That was really a diving in headfirst, the sort of 20-hour days for a couple weeks while that case unfolded. Shortly thereafter, because of that work, I was contacted by several leading companies who wanted to express their views, how corporate America felt about these really quite odious immigration policies coming out of the Trump administration. And subsequently, I led a coalition of more than 100 companies that represented many of the most substantial technology companies and from other sectors that filed amicus briefs in all of the different travel ban cases. And it was really quite important to see these very substantial interests come out strongly in favor of the rights of immigrants and how that is part of the fabric of US society. And I think that helped motivate many of the judicial decisions that came out favorably. Now, of course, the travel ban did not go our way ultimately at the Supreme Court, but the sense of corporate America, I think, helped with many of the other cases that we're going to be talking about. Now, after diving in on travel ban, the next case I got involved in around the summer of 2017 was the administration's attempts to delay the international entrepreneur rule. That was a regulation that was promulgated at the very tail end of the Obama administration. One might call that a midnight regulation, but there it was. And it was set to go into effect in around June of 2017, I believe. Right before it was to go into effect, the Trump administration purported to delay its effective date. We sued on that on behalf of the National Venture Capital Association and several leading innovators or startup founders. And we were successful in having that delay set aside, and therefore got the international entrepreneur rule active, something that some of your graduates may be using as they try to obtain immigration status in the United States if they are engaged in founding a startup company. Now, there have been some difficulties with actually getting approvals through that, and that's something that we're going to be looking forward to the Biden administration hopefully engaging on. The next case that I truly got engaged in was one that many of you all were likely familiar and helped support. That's the Guilford College case regarding unlawful presence. As you may remember, in I believe it was summer into fall of 2018, the administration announced new rules governing how unlawful presence would be calculated, rather than turning on determination of an immigration judge or USCIS. Unlawful presence would get backdated from whenever there was a technical violation of status, which, as we explained, was going to create all of these landmines where students, for completely accidental reasons, could find themselves out of status with backdated unlawful presence and then facing 3 or 10-year reentry bars. As you all know, this was incredibly problematic for higher education. We put together a legal strategy, but one of the things that was really difficult was finding institutions who wanted to stand up and sue. And we understood that entirely, because when you think back 2.5, 3 years ago, everyone was quite concerned that any institution that sued was going to be retaliated against by a fairly vindictive Trump administration. And so the concern was who was willing to stand up and file that lawsuit, knowing that you still had to deal with ICE as effectively a regulator. Ultimately, 4 schools decided to sue. That was Guilford College, Haverford College, the New School, and Foothills De Anza Community College. The President's Alliance on Higher Education was really essential in helping identify those schools and bring this litigation together. We ultimately filed a case in the Middle District of North Carolina. We were very strategic in how we approached that, and we won an injunction that barred the unlawful presence rule from going into effect. And we're hopeful that we got some good results that affected students over the last few years. Now, of course, that win is what we think directly encouraged the administration to try to change the duration of status to enter the new proposed rule that I know many of you saw, and probably all of you issued or sent comments in on that would have been problematic. We're thankful that that rule was not finalized. We were preparing to litigate on that if that came to be, but fortunately it did not. The next issue that we jumped in on is the STEM OPT, optional practical training, that I know many of your graduates use when they enter the workforce after finishing their work at that institution. There's ongoing litigation on this. Washington Alliance of Technology Workers, backed by a restrictionist organization, is attempting still to kill optional practical training. We were engaged by a series of large business interests, the U.S. Chamber of Commerce, the National Association of Manufacturers, and ITI. They're backed again by some of the leading technology companies and other innovators in the U.S. economy, who are quite concerned about the efforts to foreclose the optional practical training program. This was one of the first cases in which we truly had the full backing of the business community as a direct party into litigation. We intervened in that case in order to ensure the full defense of the legality of optional practical training. There was very serious concern that the Trump administration was going to abandon OPT and side with the restrictionist organizations, saying that was an unlawful policy. By having the large corporate associations there, we were able to push the decision-making at DHS and particularly at DOJ in order to foreclose them from abandoning that policy. We also got great amicus support from colleges. Many of your institutions joined onto those briefs. Companies, AIC filed a brief, and we put together the right coalition. I'm thrilled to say a couple, in December, Judge Walton, the judge in the case, said that we were going to win in the district court. And then a couple of weeks ago, he issued an opinion that was terrific. That case is now on appeal at the DC Circuit, where we're continuing to litigate it. So again, things look good for optional practical training, but there's still active litigation right now that seeks to foreclose that program that we are handling. The next issue that we were heavily engaged in is the H-4 EADs, work authorization for H-4 who are spouses of H-1B holders. The Trump administration had announced a planned rescission of this rule, and we were part of a pretty significant behind-the-scenes fight to try to keep to fight against that rescission. We had put together a legal strategy in the event that rescission occurred, and we had to litigate that in court. But what we also did was engaged economists who show just how impactful that H-4 EAD rule was, what rescinding it would do to the economy if about 100,000 workers were lost their ability to work in the United States. It's a particularly important rule for many reasons. It not just supports those H-4 workers themselves, but their spouses who are on H-1Bs. More than 90%, about 93% of H-4 EAD recipients are female, so they're very strong gender equity issues that are bound up in this rule. And we had economic analysis showing all of that. We also had economic analysis showing the very deep personal reliance interests that H4 EAD holders placed on their ability to continue working. We had statistics showing how many made decisions about whether to buy a house or how large of a mortgage to get based on their ability to have a dual family income. Evidence about families who made decisions whether to buy a car, to get more education, even how many kids that they were going to have based on reliance on this underlying immigration policy. And I think that strategic work at the outset helped stem what could have been a very problematic result for the administration. Now, there is also, I should note, ongoing litigation on this issue too. The Save Jobs USA case also seeks to foreclose the H4 EAD program. We're watching that litigation closely, and we've participated there as an amici, and we'll continue to do so. Last summer, I'm sure many of you are deeply familiar with the policy change about COVID and barring many international students from entering the United States. MIT and Harvard filed a lawsuit. We were engaged by the President's Alliance and we turned an amicus brief in 36 hours with I believe more than 200 institutions signed it. I think many of you, your institutions participated in that brief, and we're grateful for that. It was really important to show the widespread support for MIT and Harvard when they brought that piece of litigation, and fortunately that was a key success. Again, more recently, last summer, as you know, the administration implemented both travel bans on certain immigration visas and non-immigrant visas. We were retained again by the business community to file a lawsuit as to the non-immigrant visa ban. That was the NAM versus DHS lawsuit. We sued over the summer on behalf again of the U.S. Chamber of Commerce, National Association of Manufacturers. We also represent the National Retail Federation, Intrax. We got an injunction in that case, but one of the things, one of the lessons there is that injunction was limited. It was limited to the named plaintiffs and the members of the named plaintiffs. Now, for the business community, that was relatively positive because the U.S. Chamber of Commerce has more than 300,000 business members, and anyone can join the U.S. Chamber of Commerce. One of the challenges the higher education community faced was they mostly are not members of the U.S. Chamber of Commerce. Public institutions are outside the scope of the U.S. Chamber's charter and are not eligible to become members. Although private institutions can become members of the Chamber, many higher education institutions expressed a mission disalignment, I would say, with where the U.S. Chamber is on some of their issues and had some real reservations about joining the Chamber. That was an interesting case because when we were putting the case together, we had tried to approach some higher education organizations about joining in that lawsuit, and we were unsuccessful in getting higher ed groups to join. And as a result, the scope of relief that we achieved was reduced. Now, one of the questions that we were asked is, instead of asking for relief based on the plaintiffs, why didn't we seek relief as a nationwide injunction? And the answer on that was really quite straightforward. What we had seen over the past several years is when district courts issue nationwide injunctions, that's when it's a direct ticket up to the US Supreme Court, who in case after case after case was setting aside nationwide injunctions. By keeping the scope nominally more limited, it did not rise to the level of the Trump administration most senior policymakers, to where they directed the Department of Justice to immediately pursue an appeal to the US Supreme Court to get that set aside. So one of the lessons that we drew from there is it is very important to make sure we have associations and diverse coalitions that are able to sweep in all of the stakeholders that are affected by these different policies to ensure that the relief reaches the full scope that we think is crucial. Subsequently, again, with the support of many of you all, we looked at the regulation changes as to the H-1B program, both from Department of Homeland Security regulations restricting who would qualify for H-1Bs, as well as the Department of Labor rule that would enormously increase the minimum pay requirements for H-1Bs. There, unlike the proclamation case, we were able to manage a very strong collaboration between business and higher education. In part, that I think resulted from some of the challenges we had in the proclamation case. The President's Alliance joined as an association that was a named plaintiff in that case. And we were also joined by several higher ed institutions, Stanford, Cornell, Caltech, USC, University of Rochester, and others, to be able to sue on that regulation. It was critical to be able to present to the court not just the views of corporate America, but also how these rules directly impacted higher education. It was a very different aspect of the story. For example, the University of Utah to be able to explain how it provides a very substantial portion of medical care in rural parts of the state of Utah, and to have specialists at the hospitals and clinics in these various areas. The H-1B program was absolutely essential to them. And that's the sort of story that is far more complicated to tell if you're looking at just from a strictly corporate perspective and don't have higher education as part of the picture. So that, I think, was a very strong collaboration between higher education and the business community. Finally, over the last 4 years, I've handled multiple cases at the U.S. Supreme Court touching on different issues of immigration. I unfortunately lost a case, a sharply divided case, 5-4, called Kansas v. Garcia, that addresses whether states can prosecute individuals for making misstatements about their employment authorization at the time of hiring. We took the position that only the federal government can bring that prosecution. Kansas wanted to have the authority, and the five then conservatives on the court, including the chief, agreed with Kansas's position, and we lost that one 5-4. Subsequently, I argued a case, Guerra La Speria, about the scope of jurisdiction in certain asylum and other immigration cases, and we won that one 7-2. Argued a case about Convention Against Torture jurisdiction, Nasrallah, which we also prevailed on, and we currently have a pending case I argued a couple weeks ago, Pham v. Guzman Chavez, about a recurring question of immigration detention and the extent to which individuals can be detained. That's also ongoing. Now, with that long background, I think the question is, what do we see in the future? And I'm very optimistic about where the Biden-Harris administration is going to be taking the future of immigration policy. But I think it's important to note that there are a lot of challenges that we face and much work left to be done. So, for example, the proclamations that ban many individuals from coming to the United States on immigrant and non-immigrant visas are still in effect. Those are set to expire March 31st, but we had anticipated that the Biden administration would rescind those. They have not yet done so. I'm set to argue an appeal in our dam case next week at the Ninth Circuit, which frankly I think is unfortunate that the Biden administration has not yet taken action. We face challenges about rules the Trump administration promulgated on the way out. They finalized the DOL wage rule, which needs to be given a hard look. There's the DHS lottery rule, which we are closely considering and potentially may bring actions on. We're seeing huge delays in H-4 EAD processing, and we're considering whether or not there needs to be challenges pressing on that. Public charge, I think, is an enormous issue that is going to be difficult for the current administration to timely address, and there needs, I think, to be some external pressure applied there. Ultimately, though, what the Biden administration is going to see is, just as folks like me spent the last 4 years bringing challenges to the Trump administration's immigration policy, we've already seen that Texas and Arizona and restrictionist organizations are going to bring litigation going the other way to challenge virtually any action that this administration takes in immigration policy. They'll be strategic about it, bringing these cases often in places like Texas, where there are very conservative district courts full of judges who've been appointed over the last 4 years that get appealed to the Fifth Circuit. Again, that's a very heavily skewed court, and they're going to be optimistic about their chances in court. That puts a lot of emphasis, I think, on not just regulatory and administrative solutions, but ensuring that there is actually legislation to fix some of these key problems, because legislation is what ultimately is going to most resist judicial challenges coming from those who are going to challenge actions of this administration. So before I go on too much longer, let me stop there, Dan. I'm happy to answer any questions or thoughts you might have, or be happy to turn it over to you and Stuart.
Yeah, thanks, Paul. That was great. I'm glad to have some history and some hope. So let's move on to Stuart for his piece.
Oh, thanks. Well, as Paul made clear, it's really, even though the title of this is about what the Biden administration will do, it's pretty much impossible to talk about the Biden administration without talking about the Trump administration. And so I think what I'm going to do is look back for a while here before we look ahead. And I think really what's important is to look at what's the story of the Trump administration on dealing with international students and high skill immigration, because they're really linked in many ways. I have a Forbes article that you could look up on February 1st that covers some of this ground, but I'm going to go through some of the highlights of the story. Really, the story of the Trump administration begins before Donald Trump was elected, because there are a number of senators who were opposing high skill immigration and had different legislation. And the staffers for those senators really were the ones who went into the administration and really were the driving force on many of the restrictions. Just to give you an idea of what they were looking at, I think there's really three areas that were the focus of these different bills that later became the policies administratively through regulation or through executive action. One was mandating higher wages. Another one was stopping work at third-party or customer sites. And really another one that I think a lot of people missed was to break the link between international students and their ability to work in the United States, either immediately or longer term. And we saw that there was a bill by Senator Sessions and Senator Cruz. And as we know, Stephen Miller worked for Senator Sessions. And that bill, for example, had a provision that really is startling if it were to become law or were to have become a law. It said that nobody who is an international student could get an H-1B visa unless they had already worked 10 years outside the United States. There was maybe some slight exception for PhDs, but even then there were other provisions that would have stopped them from working too. But it would have eliminated OPT and it would have mandated 10 years outside the country. So any international student who would have considered coming to a country because they wanted to work potentially afterwards in that country would really never have considered the United States if such a provision was in there. And that's where we saw some of the administration moves as some of these staffers moved into positions and started to push things forward. I think you saw very quickly there was the Buy American, Hire American executive order that was put into place, and that really set the tone and was really referred to many times later on, including in that Department of Labor wage rule that Paul just had referred to as an authority for what they would move forward on. The other thing that you saw were memos that were really, in many cases, they weren't even public, that directed a new definition of who would qualify for a specialty occupation for H-1Bs. And what that meant is it became very difficult to get an approval, or much more difficult to get approvals. So what you saw was that denial rates started to increase dramatically in 2018 and 2019 for H-1Bs. You saw that when the denial rates were maybe about 6% in FY 2015 overall, they went up to about 24% in FY 2018 and about 21% in FY 2019. And touches on, and this became an issue, obviously, because it became terrible situation for both employees and employers, because you also had situations where people who have been working for companies for a long time who could not get extensions because under the new policies, they were basically being re-adjudicated under more difficult standards. And so you had people having to leave the country. As Paul mentioned, it's sometimes hard to get people to step forward and sue the government out of fear of retaliation. But one of the entities that did do that was a group of actually immigrants, mostly Indian immigrant entrepreneurs, led a group called the IT Serve Alliance, and they had a lawsuit in which they brought up really some of the more absurd policies that the Trump administration had been implementing as a way to prevent these companies from being able to do work on customer sites. One of the ones that I sat in on the hearing for, and one of the ones that impressed the judges was was that in at least one case, the Immigration Service had approved an H-1B visa for 1 day. And I think that kind of anecdote, as much as statistics are kind of interesting and fun to show people, oftentimes the anecdote like that can really capture what was happening, in which in this case, what was happening was really a very aggressive policy that showed really no deference at all to to business operations or the individuals who would be sponsored on visas. There also became lawsuits against the definitions of specialty occupations that USCIS had adopted, really making it almost a lottery for companies or universities to find out whether someone would be approved for a case because of the way USCIS was acting on this. Well, eventually there was success on these lawsuits, both on specialty occupation and really about a year after the IT Serve Alliance case was launched, judges ruled in favor of the plaintiffs, and USCIS had to withdraw the memos on, they first had to withdraw the memos related to the IT Serve Alliance, and then more recently they withdrew the memos on the specialty occupations. And we saw, and really what we saw, and our organization was, I think it was the only one to really measure this, because we were measuring the denial rates by quarter. What you saw through the first 3 quarters of FY 2020, you had denial rates of over 20% for initial employment. And then in the 4th quarter, it dropped down to about 1%. Extraordinary development. And the reason for that is that the previous policies that were in place were being done illegally. That's the only conclusion, because once they stopped doing those policies, the denial rates for H-1Bs went back down to really what they mostly were before, a very low rate. And from talking to attorneys, that those low denial rates have continued into the 1st quarter. So what you can see is that, as Paul indicated, that litigation not only can be helpful and really it can be decisive, and particularly in the face of policies that really show no concern for what the existing law was at the time. Now, that doesn't mean that everything is fine. As was mentioned earlier, there are really 2 regulations that are held over that can still have a very big impact on the ability for international students to work after graduation. And if you talk to university presidents, particularly in universities that rely on attracting international students in STEM fields, particularly at the graduate level, they'll pretty much tell you that if students don't think they can work after graduation, certainly on OPT, but also on an H-1B or maybe being able to be sponsored for a green card, a lot of them are going to decide that America is really not the place. We saw from looking at the statistics, we found that in Canada, the number of Indian immigrants to Canada doubled between 2016 and 2018, doubled. I mean, that is something that simply doesn't happen in immigration, barring a terrible disaster, like a war that encourages a massive flow of people from one country to another. So it's clear that many people from India have understood that Canada is an easier place to make a career and to transition from being a student to employment. And if the Biden administration is going to have a lot of repairs to do, both on attracting international students more generally and in making the employment-based system work better, so people really believe they have a chance. And on the legislative front, you're going to have to look at increasing the number of employment-based immigrants overall, and eliminating the per country limits, which particularly for people from India can cause the wait times to be a decade or even multiple decades, depending on when the person applied. On the regulatory front, these two regulations do represent a significant problem. The rule that was finalized to eliminate the H-1B lottery and replace it with a wage-based system, even the Trump administration's own analysis shows that it would eliminate everyone who would get paid at level 1 wages, and a good percentage of people who would get paid at level 2 wages. So it would basically shift the emphasis of the high skill immigration system to really kind of veterans, people who've been working for quite a while, and because of their experience would demand these higher wages. I mean, there's no country in the world that I know of that decides to base their talent stream and talent acquisition on trying to focus on older, veteran, experienced workers, as opposed to younger people who are coming right out of university. But essentially, that's what this rule would end up doing if it were to stay in effect. The other rule, the Department of Labor wage rule, as Paul mentioned, I mean, he did an outstanding job on being able to get that rule and the DHS H-1B rule set aside. But then DOL came back and finalized the rule, changed it somewhat, but really didn't change it very much in direction. So in some places where you had completely absurd wage rates, in some cases 100% increases from the existing system, now you maybe had 40% increases. We've done some preliminary analysis and found across a range of occupations that roughly 25 to 40% increases over the current wage rates that are required to be paid by employers. Again, those are very serious wage increases that a lot of employers aren't going to be able to deliver. And don't forget that it's not a matter of just paying the H-1B. In many cases, an employer is going to be in a situation: are we going to pay a different salary to someone on a visa, whose salary, by the way, will be known to the other employees because you have to actually post, information about an H-1B visa holder. But we going to give them a different salary than we give, U.S. workers? Is that a sustainable environment in the workplace? Probably not. So it's the wage rates raise a serious issue. And the Biden administration is going to have to make a decision on where they stand on this. I mean, one of the ironies of this is that if you read the regulation, in 3 key places, DOL says their really main authority and motivation was the Buy American and Hire American executive order from 2017, issued by Donald Trump. Well, on January 25th, Joe Biden revoked that executive order. So now, are you going to have a situation where the Biden administration is defending a regulation based on an executive order that the Biden administration has already revoked? Not to mention all the harm the regulation would do. So I think that's where we are. That that there's a lot of optimism. That I do think that the Biden administration will genuinely want to see an increase in international students, whereas the Trump administration, I think, really did not want to see overall, if you looked at the policies, was not interested in that, and really was interested in breaking this link between international students and their ability to work in the United States. On the other hand, there are still policies that need to be corrected, in order to have a really truly welcoming policy for international students to come study in the United States. Thanks.
All right, thank you, Stuart and Paul. Just had to get to the unmute button. I'm going to take the last few minutes and talk to you a little bit about what I've seen the last 4 years, and also move a bit off of the university campus onto some other areas of immigration law that might be of interest to you. And last, just try to reinforce the message you've heard, which is that it's been tough. And there is hope, but I think what we can do is build on all of the work that we've done and keep at it, I hope, in a somewhat calmer way. It was really interesting listening to Paul talk about the arc of his litigation over the last 4 years, from the travel ban to the Guilford College case to the current H-1B cases, where it's really shown how vital litigation was, and also listening to Stuart talking about how important research and thinking is. Sometimes when you're moving really fast, it's hard to take a deep breath and think about this. And one of the things I think we're all really excited about with the new administration is the use of, we hope, is the use of data and analysis. And I do encourage all of you to keep an eye on Stuart's column in Forbes. Some of you have heard me say this before, but it's really a great way to not reinvent the wheel. If you look this morning, or maybe it came out last night, there was an article on H-4 delays. I'm sure for some of you, you're dealing with that and answering questions from departments and from scholars. That article would be great to share with them, to show that it's not just you who filed an H-4 that's moving slowly, but this is a real issue, and it talks about the details in words, in language that can be understood. So just taking a step back a little bit, way back when I was starting off in this business, in the 1990s, there was kind of a feeling that I felt among NAFSANs that it was hard to get more resources for what you were doing. And I often saw some particular NAFSANs who were just superhuman and they get the job done, and then it made it hard for the administration to believe that any more help was needed. And we also, at that time, saw students and scholars and administrators really pushing what I felt was harder for positive, fast outcomes, and being less, and wanting guarantees. And over the last 4 years, if there is a silver lining to what we've all been through, it is that I think people understand that our work is hard, that campuses understand our work is hard. I hope you're finding that your requests for training and help and support and respect are being listened to more. And don't back off on that. Just because we have a new president. I think you've heard from Stuart and Paul that we still have work to do, and keep building on those relationships. And I think that the people we work with, the students and scholars, now understand better if we say, I'm not sure if this is going to work, or I'm not sure how long this will take. Sometimes that's the best we can do, and sometimes we just need to keep our head up and say that. At the beginning, right after the Trump election, some of you may have been involved. There were a whole bunch of meetings, sort of urgent meetings. There was one in the basement of a hotel, a NICU meeting, where there were college presidents back in early 2017. David Oxtoby from Pomona College was a real leader on this, just saying we got to do something. We got to be more organized. We've got to be ready. We don't know what's going to happen, but we've got to do something. And from that, a variety of initiatives, including the President's Alliance, which is a relatively new organization, was born, with the idea that we need an organization that is thinking about the issues that we've been talking about today. And the resources at established organizations like NICU, APLU, ACE, AAU, NAFSA, and so forth, all rededicated themselves to this kind of work and to working together. And I think what they did was they moved, even with so much happening, they moved from reacting to being proactive, to trying to be ready for what will come, to trying to think about what the next issue is, what the next rule will be, what the next litigation will be. And just as an example of what's coming now, and what one thing we really need to be thinking about that both Paul and Stuart touched on is this whole idea that wages are relevant in thinking about who's valued as a worker or in this country. We do a lot of H-1Bs for nonprofits, for community health centers, for inner city schools. H-1Bs for nonprofits are just frustrating because there is no separate wage scale the way there is for universities. And there is language in some of the proposed Biden legislation that would add in this wage test. So there's an example of something we can think about and try to advocate on over the next year. Saying that, I think we all need to acknowledge the fatigue that I think a lot of us have. I was on a call, so one of these Zoom teeny, calls where you, at the end of the day, you get together on Zoom and everybody has a drink. And with some of you folks from all over the country. And it moved to talking about what we would do if we weren't doing what we're doing. I think most of us started our careers thinking, God, this is the greatest job in the world. I never want to do anything else. I still feel that way, but I think we all sort of had to take a step back, that if the pace had continued the way it was over the last 4 years for another 4 years or 8 years, I don't know, we might have lost, some really good people in the field. So let's just take a moment to acknowledge that, to understand that stress, they say, is like secondhand smoke. It was everywhere. It was, as much as we have our mechanisms for coping, it was there. And we need to take a deep breath. And now that we do have a chance to breathe, again, let's rededicate ourselves to what we've done and take on and look and see that there is optimism, that we can now stop fighting and start thinking about positive changes. We can head into the rest of this SIW workshop, or spring immigration workshop, with some more energy and skip in our step, and see that the courts are not perfect. Paul will tell you that, but checks and balances work in a lot of different ways. Oh, sorry, I think my dog's going to bark in a minute. And we've heard from Stuart that research and data matter. And that's another thing that we're really excited about from the new administration. So quickly, I will move on to a couple other areas of immigration law that I think are interesting for you. Hot topics, DACA. It's been really amazing to see people apply for new DACA over the last few months. Since 2017, when President Trump paused the DACA program, students who got older, old enough to apply, couldn't apply. And a lot of times you had younger siblings where their older siblings had DACA, the younger siblings couldn't get a work card, couldn't get a driver's license. It was just, and couldn't see a path to what they would do with their education if they can't get a work card. So that's been very exciting. There is still litigation, just as there is with everything else, but I'm very happy that DACA is back, and the ability to travel with DACA is back, which, once we get further along in the pandemic, will allow students to do study abroad, research trips, and see family members and so forth. And then in terms of what's going on at the border, we're in a huge transition period. There is, as you may have read in the last few days, a wave. I don't want to use a negative word. There are an increasing number of people who are moving toward the southern border. How the Biden administration handles that will have a tremendous impact, I think, on the way immigration is perceived. There are moves to try to eliminate private detention facilities, which really are just bad. And there's a move to try to make sure that we keep a lot of the due process that was lost in terms of applying for asylum and to try to work through the huge backlogs of immigration court cases. So that's something we're really going to be watching. In related areas, Paul mentioned that he did some of the initial litigation on the international entrepreneur parole rule. We're kind of excited to see some of the Obama era efforts on trying to support entrepreneurs, even though the immigration system wasn't set up to support entrepreneurs. And Liz Goss, who helped organize this session, I think is one of the only lawyers in the country to be successful on the international entrepreneur parole rule this year. But we hope that will grow and that there will be more opportunities for entrepreneurs. And we hope that some of the support for healthcare professionals that's been brought into immigration law will continue. Expedites for healthcare workers, so that they don't have to wait forever on an I-539 to get their J1, or are there, and we hope that will continue, just as because we're in a political moment where we may be able to capitalize on some of that and lock in some of the benefits that are there for healthcare workers. So in winding down, I say please keep at it. Don't give up. Don't say that now that we have a new president we're all set. We're not. Keep up your connections on campus with your government relations, with your media relations, with your counsel's office. Keep writing comments when regulations are proposed. Keep listening to your professional organizations. So if there is litigation or amicus or anything else, that you consider it. Read Stuart's column. And I hope it won't be fast and furious this year the way it was before, but it is still serious. And the other thing I look forward to, which was really sad to lose, was liaison with the agencies themselves. We all know that we deal with legal issues and complex legal issues, but a lot of what we do for people is try to help them navigate a bureaucracy that has not the greatest technology and that can make mistakes and that can be slow in responding to mistakes. And when we lost, real liaison between NAFSA and AILA and the agencies, it was tough. So I'm hoping that will come back, and I hope that many of you will get involved in that kind of work, because it really is important, creating those personal relationships with individual government officers to discuss issues politely, present problem cases, and do that. And on a bigger picture, I know that NAFSA and the President's Alliance and others are advocating for the bringing back the Homeland Security Academic Advisory Council. That'll be a forum that was stopped during the Trump administration that will allow regular discussion of all these things. They're pushing for special student relief, which would be trying to have a more organized way of dealing with the pandemic instead of just waiting and wondering whether the March 2020 memo still applies and to what extent it applies now. We need to know what the policy is. I'm hopeful that through liaison, top to bottom, that we can do that. And so I end with what I hope is a positive message. I hope we can get that message out to our students and scholars, because they need it. They've faced a lot of uncertainty. They're still reading things in the on listservs and hearing things that are of concern, and they need to know. But I am optimistic. I am relieved, and I am redoubling my effort to try to make the world a better place for international students and scholars over the next 4 years. So with that, I say thank you. Enjoy the conference, and I'll turn it back to Andrea.
Thank you, Dan and Paul and Stuart. This has been an excellent start to our workshop, and really gives a lot of perspective with regard to what has been going on, and the need for continued advocacy as we move into another chapter, another administration, and how important that remains in our world. And hopefully, like you said, Dan, hopefully we're starting out from the perspective of having a little bit more visibility in our institutions, but that still so important to fight on many of those advocacy efforts. I'm going to turn it over to our Spring Immigration Workshop Coordinator, Shannon Gerber, who's going to talk a little bit about what's coming next with regard to our virtual SIW. Shannon?
Thanks so much, Andrea. Hi, everyone. Thank you for coming, and thank you to our wonderful panelists for a great opening of this much beloved Region 11 event. It looks a little different this year, but we are still so excited to bring it to you all. So as you know, we are gonna be virtual for Spring Immigration Workshop, and instead of one day of Immigration Fun, we will be doing multiple sessions every week for the next 2 months. You can find the full schedule at this website, which is our NAFSA Region 11 website. You can go there and find the Spring Immigration Workshop section. It will be updated frequently with registration links for all of our sessions. We have tons of sessions over the next couple of months, ranging from employment things, so many employment things, taxes, J1, H1B, F1 basic training for new DSOs in your institutions, lots of different offerings. So please take a look at the full list and check back frequently. You'll also receive emails every Wednesday from Ozan. Ozan Say at Yale, who's graciously taken the job of sending all our communications. So please watch for those that will announce new sessions or new registrations being opened for all of the sessions that we have available. Additionally, it's free this year. So if your institutional budget has suffered during COVID, please make sure that you and your office mates all take advantage of our offerings. You can also find news and updates on the NAFSA Regional 11 Facebook page. So please join that page as well for all sorts of updates from our region, GRAC and otherwise. And I hope to see you and our full SIW team and GRAC team hopes to see many of you at our sessions coming up. And we wish you a wonderful spring, hopefully soon, and a wonderful spring semester, and we'll see you soon.
Thank you all.